The broadcast is now starting. All attendees are in listen-only mode.
Well, good afternoon, everybody. My name is Matt Godson. I'm co-CEO with Momentum Events. It's my great pleasure to welcome you here today for this afternoon's webinar entitled Life Sciences Enforcement Year in Review, examining hot-button areas for FDA and related government enforcement. It's my great pleasure to introduce our two co-presenters this afternoon. First up, we have Annie K. Walsh, who is the director with Hyman, Phelps, and McNamara, PC, and former Associate Chief Counsel with the U.S. Food and Drug Administration. Annie counsels clients on enforcement issues, applying more than 15 years of litigation experience gained while working on behalf of FDA and industry. She focuses on allegations of fraud relating to marketing and promotion, healthcare, or clinical studies, with particular emphasis on cases involving joint criminal and civil investigations under the Federal Food, Drug, and Cosmetics Act and False Claims Act. She's joined today by Peter S. Spivack, who is the partner and co-leader investigations white collar and fraud practice area and a former federal prosecutor currently with Hogan, Lovells, LLP. Peter's experience in the criminal arena includes antitrust, banking, campaign finance, environmental, food and drug, Foreign Corrupt Practices Act, healthcare, and government contract matters. Peter has worked with numerous companies and organizations in defending grand jury investigations, as well as conducting compliance audits and internal investigations and monitoring and improving compliance programs. Just a little housekeeping before I hand over to Annie. We will be making the slide deck available after the presentation. If you want a copy of the slide deck, please email me, Matt, M-A-T-T, @momentumevents.com. This session is also being videoed, so the slides and the audio are going to be put together in a presentation, and that will be made available afterwards. Everybody that is registered to attend this presentation will receive a link after the event with details on how to download the slides as well as how to access the video afterwards. The presenters will be having a Q&A session at the end of this session. This will be handled by my colleague Sansare McCall, who is also on the line. If you have a question for us, please use the chat box, which is part of the GoToWebinar panel. It's probably like the sixth or seventh panel down. I'll place a little note in there in a minute so that you can see exactly where that is. And please use that question panel in order to make your question to both of our panelists. Well, with that being said, I'm going to hand it over. It's my great pleasure now to hand it over to Annie K. Walsh for the first half of the presentation. Annie, over to you.
Thank you, Matt. Good afternoon, all. The way that Peter and I decided to split up this panel is for me to talk first about enforcement trends that are going on internal to FDA, and that he would take the external to FDA, the DOJ and beyond focus. So for the first half, I'm going to talk about what goes on within FDA, how they determine what issues are worthy of enforcement, how they decide to proceed on that, and kind of some of the trends that we've seen and we expect to see in the upcoming year. So I'm going to walk through the goals of FDA enforcement, the relevant offices that are implicated in enforcement efforts within the agency, available enforcement tools that FDA has that it can administer and implement on its own, and then the regulatory priorities and trends that we've been watching and that we anticipate will occur in the next year. So from FDA's website, you see that the goals of their enforcement activities are fairly traditional to start off, to protect public health by intercepting unsafe or fraudulent products and to prevent additional harm from those products. So that's your typical, understandable, traditional goal of protecting public health that we're all aware that FDA's mission is. The second is to deter others who might violate the law, so a deterrent effect. That is one of the principles of criminal law. The third is to inform the public of potential harm. So this is what they do through publicity and getting the word out about potentially adulterated or misbranded products. But the third and fourth goals I thought was very interesting. I wanted to highlight those for you. The third one is create a level playing field for industry. And you wouldn't think that that was a traditional goal of a U.S. government agency, but it's they identify that they want to create a level playing field so that industry is all playing within the same competitive factors. And the last one seemed a little bit self-serving, that they wanted to instill public confidence in their own agency. So with those goals in mind, we can identify and look at what FDA intends to do in the future. The relevant offices within FDA are many. The way that they're organized is quite complex, and I'm not going to try to go through each potential and relevant office that might be implicated in an enforcement activity. But I wanted to highlight the key ones that you might be dealing with if you would become an unfortunate subject of an enforcement action. So the lead office for all the field activities at FDA is the Office of Regulatory Affairs. And this office and the field offices are the ones that you'll likely deal with the most in your everyday encounters with the agency. They're the ones who conduct the inspections, who issue the inspection reports and 43s that result from inspections that you would be notifying in the event of a recall. The district offices are those folks, and that's all within the umbrella of ORA. The current ACRA, the Associate Commissioner for Regulatory Affairs, is Melinda Plaisir. And their goals and activities are many. They inspect regulated products and manufacturers. They conduct sample analyses, and they review imported products. And they're divided out throughout the country. There's 5 main regions, 20 district offices within those regions, 13 laboratories where they conduct analyses, and more than 150 resident posts and border stations. So they are located throughout the entire country, and they're the general typical face that most of industry will look at with respect to FDA regulation. Underneath ORA is the Office of Criminal Investigations, and this is somewhat of a unique setup for a criminal law enforcement agency. OCI considers themselves counterparts with law enforcement agents such as FBI or the IRS or a Secret Service agents, but they are within a regulatory agency at FDA and underneath the Office of Regulatory Affairs. So it's a somewhat unique structure for law enforcement agents, and that does lead to some dysfunction within the agency as to who has authority over them. Their current director is John Roth, although he has been nominated to be the Inspector General for Department of Homeland Security. So pending his confirmation, he is the current director, but that may change if he is confirmed. Their mission is to protect public health, just like FDA as a whole, and they have more tools in their belt than the typical regulatory agents might have. They carry firearms, and they execute search warrants, and they liaison with U.S. Attorney's offices directly, unlike the compliance officers or investigators who might be conducting the inspections on site at your facility. FDA is composed of several centers that have oversight over their various regulated product areas, such as devices and drugs and foods and vet meds. Each center has its own Office of Compliance. So there's a lot of coordination that needs to be done within FDA to determine what are the enforcement priorities for the agency as a whole, and each center has its own enforcement priorities. CDRH, which is the Center for Devices and Radiological Health, has its Office of Compliance, and it used to be a very bare-bones operation. They had one director, Steve Silverman, who remains as director, and he had a handful of staff members underneath him, I think somewhere between 10 to 15 staff members that conducted all the compliance activities for CDRH. In November of 2013, just last year, CDRH announced that they were going to do a massive reorganization, and they were going to divide out into 5 separate divisions. The divisions include analysis and program operations, where they would be looking at trend data and evaluating what sort of information they receive from recalls and determining what sort of information they can garner and consider what enforcement actions to take from that. Bioresearch monitoring, international compliance operations, manufacturing and quality, and pre-market labeling and compliance. And what's notable is that pre-market labeling and compliance used to really only be run by 2 people within Office of Compliance. But Steve Silverman just recently stated that he expects and anticipates that this office or division within Office of Compliance would grow to up to 20 people. So the CDRH intends to really start focusing on labeling and compliance with approved labeling based on this reorg. CDER, the Center for Drugs, also has its own Office of Compliance. They have a new acting director who's Carol Bennett, and you'll see that they have already been established for having similar divisions to what CDRH is now trying to reorg to do. They have a Drug Security, Integrity, and Recalls Office, a Manufacturing and Product Quality Office, Scientific Investigations Office, Unapproved Drugs and Labeling Compliance. And as you'll see on the next slide, they also have a special office focused on prescription drug advertising. But you'll see that these offices run very parallel and analogous to how CDRH intends to now run its Office of Compliance. And I think that's just a signal that CDRH intends to be more heavy on its enforcement activities than it had been traditionally. So, like I said, the Office of Prescription Drug Promotion, or affectionately known as OPDOP, within CDER, is actually a separate office outside of Office of Compliance. This is not what CDRH has now, even with its new reorg. DDMAC, which is what OPDOP was in its past life, used to be a division at the division level, which was underneath the Office of Medical Policy. But they were promoted to the office level a few years ago and changed their name to the Office of Prescription Drug Promotion. And they have a very large staff and a very large number of resources in order to address all the promotional activities that relate to prescription drugs. So just last week, on February 3rd, Commissioner Hamburg announced that there will be a new realignment project to centralize enforcement at the agency. So what her plan is to add more specialized people to FDA's workforce. And this is going to affect investigators, compliance officers, import reviewers, lab personnel, and managers. So ORA, which we talked about earlier, is going to work with the centers, each of the drugs, device, foods, vet med centers, to develop new compliance policies and enforcement strategies and try to coordinate that within FDA. And part of the project is also to delayer the reviews necessary for certain enforcement activities or decisions that need to be made so that they can occur more quickly and efficiently. So the next step for the realignment project at FDA is that each center director will need to create an action plan affecting
Pardon the interruption, everyone. This is Sunny. Annie, we lost your audio there. I'm not sure if maybe you hit the mute button.
Annie, I don't know if you can hear us, but Sunny, perhaps we can, while we wait to get Annie back, perhaps we can switch to Peter for his part of the presentation while we work on Annie's technical issues.
Absolutely.
All right, this is Peter Spivack. Thanks very much, Annie. Sorry about those technical issues. What I wanted to do in this part of the presentation is review the major areas of federal and state enforcement in the past year and a half. One thing I think that's quite apparent is life sciences companies are still a very active area of enforcement. We still have lots of criminal cases. We still have lots of civil False Claims Act cases. In the False Claims Act area, for example, the Department of Justice reported $3.8 billion in recoveries in fiscal 2013. Much of that came from life sciences cases. And remember, DOJ's fiscal year ends September 30th, so that does not include the $2.2 billion that Johnson & Johnson paid in a settlement announced on November 4th, 2013. One of the things that we've seen is that states are becoming very active. And what they're doing is they're really taking advantage of their consumer protection statutes. And they're using them to enforce what may be considered FDA violations against life sciences companies and others for what is considered deceptive practices or deceptive advertising. We've still got lots of anti-kickback schemes. We have also a trend that may come into fore that I'll talk about a little bit more later about current good manufacturing procedure cases. As I'll note, in the past, those have been primarily resolved through consent decrees. So one of the things we'll talk about is whether or not there is a coming wave of enforcement. All right, so in terms of the major action in the last year, one of the cases that I'll talk briefly about is U.S. versus Coronia. That was hailed by many commentators as potentially the death of off-label enforcement. But as U.S. versus Harkonnen, another case that came after, and the settlements listed here, J&J and Par Pharmaceuticals and Amgen, as well as the device settlements, all of which came after Coronia, the Coronia decision in December 2012. As Mark Twain might have said, reports of the death of off-label prosecutions might be greatly exaggerated. I'm going to touch briefly on Par, Amgen, and Boehringer Ingelheim, as well as some of the device settlements on this slide, and then talk a little bit more about some of the other cases. The Par case is interesting. It involved a product called Megace. Megace was approved by the FDA to treat anorexia, cachexia, or other significant weight loss suffered by patients with AIDS. It was distributed or allegedly promoted by Par in nursing homes, not generally thought of as a place where a lot of AIDS patients may reside, because it was found to be effective in geriatric wasting in patients who were elderly but couldn't gain weight. Par pleaded guilty in March 2013 to a misdemeanor for misbranding Megace and paid $45 million in total. This is an example of the most simple kind of off-label promotion case, an unapproved use that's proved by the composition of the promotional population, i.e. old people in nursing homes. Amgen's another case that was interesting in April 2013. This was a False Claims Act case that included off-label promotion allegations. Amgen resolved the case for about $25 million, and it was basically a kickback case relating to a drug called Aranesp, which is indicated for anemia associated with chronic renal failure. The kickbacks allegedly took the form of performance-based rebates that were tied to market share or volume thresholds. These have been very common tools for pharmaceutical companies looking to improve market share, and yet the government believed that they were objectionable here, in part there was evidence that there were materials that promoted Aranesp for patients who didn't have anemia associated with chronic renal failure, but had other types of anemia. Sort of another species of off-label promotion where you take a limitation on a label or indication and promote outside that limitation. Boehringer Ingelheim was actually settled in October 2012 for about $95 million. That related to a drug called Agrinox, which was a stroke prevention drug. There were also a number of other drugs, including Atrovent and Combivent, which were for COPD, and Micardis, which was for a hypertension condition. This was an interesting case because there were an array of off-label promotional claims. First, there was dosing, that Boehringer promoted Combivent and Atrovent, the COPD drugs, at doses that exceeded those covered by federal health care programs. Second, there was efficacy, that Boehringer knowingly made claims about the efficacy of Agrinox, which is a stroke prevention drug, including that it was superior to other therapeutic class drugs like Plavix. There were also unapproved indications that Agrinox, which was approved to prevent secondary strokes, was promoted for certain cardiovascular events such as myocardial infarction and peripheral vascular disease, again, not within the narrower indication. And then finally, there was a combination use allegation that Combivent was marketed for use prior to another bronchodilator in treating COPD. So you really saw a whole set of off-label promotional claims, different species of claims. Devices have also been started to become an active area of enforcement. This has been interesting, generally in terms of compliance, and this is a very general statement. We've seen that device companies, are a little bit behind pharmaceutical companies in terms of their compliance systems. There are a couple cases here that I've noted. One was Trans1, which became Baxano Surgical. That was a False Claims Act case that involved both reimbursement issues and promotional issues. The device there was a spinal device called the Axiolift. It was used essentially to join the lower lumbar to the upper sacrum, and it was approved for that use. And the government's concern was that it was being promoted for essentially like the base of a multi-level fixation. So you had multiple levels of vertebrae. It's a good illustration of the spine as an area of great concern for FDA in terms of how spinal products are promoted, and whether they're promoted for uses outside their indication. FDA has traditionally shown a lot of concern over the spine and devices used in the spine. Orthofix, a different case, that involved something called bone growth stimulators. That's essentially a way of stimulating bone growth to regenerate bone. And here the issue was there's certificates of medical necessity that were needed for Medicare to approve payment for these devices. So they had to be filled out and signed by doctors, essentially saying there was a medical need. And apparently the problem, according to the allegations, was that sales representatives at Orthofix were actually completing the forms, including the medical necessity section, and at times they were forging physician signatures. The resolution of the case was interesting because rather than resolve it, it was a criminal resolution, and rather than resolve it on an off-label promotion felony, what the government did essentially is agree to a charge for obstruction of an audit. And the reason that they chose obstruction of an audit by a Medicare contractor is that that's actually one of the few crimes that's a felony that will not lead to mandatory exclusion by HHS-OIG. So instead, it's a permissive exclusion, which allows the company to enter into a corporate integrity agreement and preserve its ability to obtain federal reimbursement through Medicare, Medicaid, and other federal programs. Okay, so let's talk a little bit about Coronia. And I apologize if you keep seeing this warning flash on the screen. So United States versus Coronia was an interesting case. It involved a product called Xyrem. Xyrem is manufactured by Orphan Medical. It was a central nervous system depressant indicated to treat symptoms of narcolepsy. It's kind of a dangerous drug because the active ingredient is GHB. GHB is, what has become known in press accounts and urban legend as the date rape drug. So very serious active ingredient. So Xyrem had a black box warning, the most serious warning placed on medication labels. The company actually pleaded guilty to felony misbranding and paid $20 million to resolve the case. And then the government went forward and actually charged individuals, some of whom pled guilty. But one of the people they charged was Albert Coronia, who was a sales representative, and they had him on tape with a doctor who was cooperating, talking about other uses for the drug, fibromyalgia, insomnia, other sleep disorders. He went to trial. He was convicted of conspiracy to commit misdemeanor misbranding. He got 1 year probation, community service, and a $25 special assessment. So he argued on appeal that his conviction was solely based on his speech, and that as a result, it was protected speech under the First Amendment. And the Second Circuit agreed with him and basically said that the First Amendment protects truthful, non-misleading speech, even if off-label. And the government's prosecution was really premised on that speech and nothing else. So when this decision came out in December of 2012, there was a lot of prediction that this was the end of off-label prosecutions because the Second Circuit had recognized the First Amendment defense. Harkonnen, which came after and was a Ninth Circuit decision that came out, it was an unpublished decision, came out March 13th, 2013. Harkonnen actually shows where the government can prevail, and I think if you talk to prosecutors, where the government feels it's always been, which is that if you have speech that is either not truthful or misleading, that can be the basis of an off-label prosecution. Here it revolved around a press release. The press release related to Intermune's drug. Intermune's drug is called Actimune, and it treats something called idiopathic pulmonary fibrosis. It's a terrible disease. It essentially involves progressive scarring or fibrosis in the lungs. It had been, the drug was approved for a very, very narrow indication, 2 rare pediatric conditions, not idiopathic pulmonary fibrosis or IPF. But that was a big potential use. And so the company undertook a clinical trial, phase 3 clinical trial, to determine whether or not Actimune delayed or prevented the worsening of patients' IPF. What happened in the clinical trial? Well, I think there were something like 7 clinical endpoints, and they missed all of them. So they didn't get any single one of the clinical endpoints. So Scott Harkinen, who was the CEO, directed his staff to conduct some analyses to determine whether or not Actimmune could be effective for subgroups of the IPF patient population. And those suggested that maybe for mild to moderate IPF patients, there was some improvement. So Harkinen and others met with FDA, and FDA said essentially, you know, this isn't enough data. We can't give you an IPF indication. You need further testing. Well, then after that meeting, the company issued a press release that was nationwide that said that it had achieved favorable results for mild to moderate IPF in its clinical trial, and it reduced mortality by 70%. And so Harkinen was shown to have actually wrote the headline and the byline and controlled the content of the entire press release. And so he was indicted, and the indictment basically alleged that the press release was false and misleading. And he went to trial. He was convicted, and the Ninth Circuit affirmed the conviction, basically saying there's no First Amendment defense here. There's no genuine scientific debate about how the phase 3 trial results should have been interpreted. Instead, the jury found beyond a reasonable doubt that Harkinen issued the press release, he had the specific intent to defraud, and that finding supported by the evidence presented at trial. And so the Ninth Circuit said basically, we're not disregarding that factual finding to overturn the conviction. But what you see is, you see speech, but it's speech that is not truthful or, at the very least, very misleading. And that was the basis of the conviction. So after that, we've had these different settlements, including Johnson & Johnson, which was the third largest settlement by a drug company in history. It was actually a combination of a couple of cases and several drugs, but basically you had $2.2 billion in fines and False Claims Act civil settlements. There were 3 drugs involved. It actually wrapped in an earlier misdemeanor plea by Johnson & Johnson's subsidiary Silas. And the conduct basically involved, first, the promotion of some very serious antipsychotic drugs, Risperdal and Invega. Those were indicated for bipolar disorder and schizophrenia, and they were being promoted for allegedly elderly patients with Alzheimer's and dementia. And if you look at the Risperdal label now, it actually has a black box warning saying there's an increased likelihood of severe side effects, including death, in elderly patients with dementia. So there was a significant public health element here. It also involves something called Natracor, which is indicated for acute congestive heart failure. So that's inpatient, but it was being promoted for outpatient cardiovascular use. And you saw the government wrap in other promotional vehicles, market share rebates, data purchase agreements, speakers' fees, and essentially characterize those as kickbacks. The corporate integrity agreement has now put J&J under until October 2018, and there were some new provisions that were somewhat significant in the CIA. First is there are clawbacks. The company had to agree that in any employment agreement it makes with senior executives, it can essentially has to have the right to claw back bonuses and other long-term incentive compensation, stock awards, etc., if there are violations of the CIA that are later determined to have happened under that executive's watch. So it's an attempt to really impose individual personal consequences on executives so in the government's view, they will then be impelled to be responsible for the conduct that's under their purview, under their supervision, under their responsibilities. They're trying to do that the same thing with the board of directors too, as well as the senior executives, in making them personally certify. I mean, they literally have to sign a certification every year that the company has complied with the CIA. But what that means is they have to build a structure underneath to ensure that the certification can be made knowingly and not willfully disregarding some concern. So there has to be reporting up that supports the board and senior executive certifications of compliance. Another thing that's introduced is there's now a very lengthy attachment that's been developed over several CIAs requiring the company to do risk assessment and mitigation planning. And this is essentially an effort by HHS OIG to introduce principles of risk management at the entity level and entity level control assessments, so that there is a forward-looking assessment of risk in any program or activity that's undertaken. And then finally, there are some very, very detailed controls over third-party educational programs, so the companies can't outsource off-label promotion through third-party educational programs. Another thing that happened in the industry that was quite interesting after this J&J settlement was announced, about a month later, on December 16th, 2013, GlaxoSmithKline, the largest pharma company in the world, announced that it will no longer pay doctors to promote its products, and that it would stop tying compensation of sales representatives to the number of prescriptions that doctors write. So it essentially ended two very common practices that have come up again and again in these cases. So there's no longer speakers programs for doctors at GSK, and there's no longer sales reps getting incentive compensation or bonuses tied to the increase in the prescriptions. The idea is that that will take out the incentives for pushing the envelope, so to speak. So it'll be interesting to see how that actually translates and how effective it is. Another big trend, state enforcement under the consumer protection laws. The Wall Street Journal commented that a key appeal of these types of cases is that they generally don't have to prove, that is, the state attorneys general don't have to prove that a drug maker's marketing caused any specific injuries or harm. They only need to convince a judge or jury that the promotion was deceptive in some way. So there are some examples listed here. I'm going to pick one of them, which is just this J&J case. So J&J, and this is separate from the $2.2 billion that they paid in November 2013. In 2012, they were fined $1.2 billion in Alabama. And a state court jury found the company violated state consumer protection laws and Medicaid fraud laws in marketing Risperdal. And that's their antipsychotic product. What the judge did after the jury's finding was take one of the unique features of these consumer protection statutes, the per occurrence penalty. And he imposed a $5,000 penalty on each of the 4,570 estimated letters that J&J sent to doctors in 2003 in Alabama. The idea was that the letters were allegedly misleading because they contained information about Risperdal safety, but did not convey the risk of elevated blood sugar levels. So J&J has appealed that fine, and oral arguments are actually scheduled now for February 27th in front of the Alabama Supreme Court on the case. The GSK case also shows another trend. Very often you get in these cases, the states will all band together. They'll join in settlement. They'll parcel out some settlement proceeds based on relative shares of a market. But GSK actually had a situation where it was sued by Kentucky and Maryland in February of 2013 over the promotion of Avandia, which is a diabetes therapy. Kentucky and Maryland actually opted out of a $181 million settlement of consumer protection claims by 37 other states. And GSK ended up settling. And on July 24th, it announced it had reached an agreement in principle with the attorneys general of 8 states, including Kentucky and Maryland, to pay an additional $229 million to settle Avandia and other claims. So you see states possibly acting on their own, going on their own, essentially not participating in these settlements because of the potential for significant additional awards, and all under these consumer protection statutes. The anti-kickback statute, I wanted to mention the Sanofi-Aventis settlement in December of 2012. It was a significant payment, but part of the thing that's interesting about this is you see, I think when I first started in private practice, we had all these cases involving average wholesale price, and average wholesale price was, then the basis for pricing drugs that were dispensed and reimbursed by doctors. The spread between the price, the acquisition price, and the sales price, or the reimbursement price, could be used to reimburse doctors or encourage them to buy product. Well, there's now a new system. It's average sales price. It is supposed to try to eliminate the AWP problem, but you see a variation of this where there were free units of product given to physicians to lower the effective price and therefore increase to physicians the financial incentive that they had to buy the product. Last area that I will cover is the current good manufacturing practice area. What you see here are some companies that were the subject of consent decrees. Each of these consent decrees, which were entered in, the major ones I think entered in 2013, each of these involved a failure to comply in the manufacturing process. And generally they stemmed or resulted from inspections by FDA, and FDA found unsanitary conditions. In some instances, there were contaminated products, failure of sterility, basic maintenance issues, equipment that wasn't maintained where it deteriorated and shed particles into injectable drugs. I mean, really things that are real problematic from the standpoint of having a manufacturing process that is controlled and replicable and has sufficient quality to deliver products that can be used by the public. Each of these consent decrees imposes conditions where the companies have to get back in control, and that control has to be verified essentially by a third-party expert that's retained. Ranbaxy, a major Indian pharmaceutical manufacturer, has had real problems with this, real problems trying to get back in compliance. It originally had a consent decree that was entered in January of 2012. It was extended in September of 2013. So Ranbaxy has not been able to supply any products from particular facilities in India to the United States until it satisfies FDA. And so, that could be another 2-3 years. And so from that point, Ranbaxy can't file additional applications for drugs from that facility either. And it was interesting. Today there was actually a report in the press that Margaret Hamburg, the FDA commissioner, on a visit to India, actually had a personal plea made to her by the CEO of Ranbaxy to allow Ranbaxy to continue exporting from the manufacturing facilities that are problematic while they take remedial measures to rectify the issues that have been flagged. It's not surprising, I suppose, that Commissioner Hamburg turned that down flat. So, are these CGMP cases the next wave? It's certainly something that the DAG for CPB, the Consumer Protection Branch, has indicated may be something that could represent future cases, whether they're Civil False Claims Act cases or criminal prosecutions. And we may, in fact, see some of these cases developing in the future. So thank you very much for listening. Annie, I don't know if you're back in communication.
I am.
I will hand it back to you.
Great. Okay, so I think where we left off was where I was talking about the major realignment that FDA intends to do, and that the center directors need to set up action plans by October 2014. So a lot of the enforcement strategies will evolve throughout this year and as they institute those action plans. So anyway, I want to take you very quickly the enforcement tools that FDA has available to them. The first slide deals with the administrative tools that they have that they can institute on their own without involvement from courts or DOJ. And so here's a listing of them. We're going to talk about briefly the untitled and warning letters that FDA has issued against companies for a lot of their promotional conduct. The court-involved enforcement actions involve seizures, which are court cases against the goods themselves, the products themselves that are adulterated or misbranded. And the owner then has to intervene to defend the goods, or if not, then the goods end up being destroyed. Injunctions, which are civil actions that are brought against the company and or the individuals. Usually FDA tries to hold individuals accountable and liable in their injunction actions. And they are intended to compel compliance with FDA regs and prevent future violations. And they are usually resolved in settlement using the consent decrees that Peter just mentioned. The Shamrock, the MedPrep, the Benvenue, and the Ranbaxy consent decrees are some recent ones that happened. And the consent decrees themselves usually require significant compliance and monitoring measures, such as those that are contained in the CIAs as part of a resolution under the False Claims Act. Other enforcement tools I put in here are disgorgement and restitution, which are avenues for FDA to recover monies. And I also just want to take through quickly the techniques that FDA has in order to gain information and evidence to support its enforcement actions. Its primary one are inspections. And there are several types of inspections. There's some that are planned pursuant to a compliance program. There are some that are required as part of a pre-approval of a product. There are some that are directed or for cause, meaning that there's some reason why FDA has received allegations that warrant going into a facility and inspecting. And then there are some that are conducted in conjunction with other agencies as part of their collaborative efforts to protect health. The IOM, the Investigations Operations Manual, governs the methods in which inspections are to occur. And the statute, the Federal Food, Drug, and Cosmetic Act, allows investigators to access records, certain records, on-site at a facility and As a result, also, investigators routinely seek to interview witnesses and take photographs to support their inspection findings. There was a guidance that FDA issued last year that relate to a new provision in FDASIA that deems a product adulterated if a manufacturer delays, denies, or limits an inspection. And in that guidance, the FDA explicitly states that investigators have a right to take pictures. A lot of that has been controversial throughout the years as to whether or not they have the right to take photos on site. But FDASIA, which now includes this provision, this adulteration provision, and along with this guidance, seems to show FDA really wants to be able to have that ability to do so. That has not been challenged in court to date. Just also OCI, which is the criminal investigative agency within FDA, has some additional authorities to gain information, to gather information to support its enforcement activities. They do trash runs, they can execute search warrants, and they can issue subpoenas for information, just like other law enforcement agents can. So I know we have a very short period of time. I want to go through what I see and what we've seen as potential trends and priorities for the agency. Under advertising and promotion, I mean, that's clearly been a big focus. That's been a lot of what Peter talked about with respect to the large settlements that have occurred over the last year. And within FDA, they can issue warning and untitled letters that have a lot of collateral consequences associated with them. Opie-dopey is the prescription drug branch that issues warning and untitled letters. And last year in 2013, they issued slightly fewer than they did in 2012. But I don't think that's necessarily a trend of fewer enforcement. I just think that's probably as a result of what they were working on throughout the year. Already in 2014, they issued an untitled letter to Mission Pharmaceuticals relating to its drug product Tindamax, which is a treatment for a sexually transmitted disease, trichomoniasis, and bacterial vaginosis. And one of the things that was interesting about this untitled letter was that FDA took issue with the fact that they downplayed the black box warning that's contained on the product labeling. The black box warning related to the potential risk of carcinogenicity, and they did not, in FDA's view, highlight that warning or risk sufficiently. One notable warning letter that was issued last year that a lot of folks have paid attention to is was issued to Agerian Pharmaceuticals, and it was based on statements that the company CEO made to the investment community rather than to physicians and patients, as most of these promotional activities are focused. And that was notable for that very reason, that it's clear FDA is looking at the intended use and gaining evidence of what a company's intended use for a product is from all sources, not just physician and patient communications. Opie-dopey is also focused on claims made in the company's press releases. So not only are they looking at TV shows in statements, oral statements made there, but also in press releases, again, focused to the investment community, not necessarily to the physicians and patients that are receiving and buying these products. So I list a few here that Opie-dopey recently issued, and it's clear that between 2001 and 2012, they did not issue very many related to news releases, but that their focus has certainly increased over the last year. And devices are not flying under the radar. Again, as Peter highlighted, devices are starting to be become one of the focal points for DOJ prosecution and investigation, certainly within FDA with the reorg in CDRH Office of Compliance. You can expect that devices and their promotional activities are going to be a hot button area. And in the recent past, you can see that CDRH has issued warning letters by reviewing the websites of companies, which again is not your traditional promotional labeling, but that that FDA has taken the position that websites are labeling and certainly evidence of intended use. So you can expect, I think, that a CDRH is going to be looking at other sources, just like CDER is with respect to drugs. FTC is the agency that has authority over advertising of all foods, drugs, devices, and cosmetics except for prescription drugs. So Opie has carved out under a memorandum of understanding that it is has regulatory authority over prescription drug advertising, but otherwise FTC does. But what was interesting is that last year FDA and FTC issued a joint untitled email to various distributors of contact lenses saying that they consider the products adulterated or misbranded or false or misleading under the FTC Act. This is an unusual action and something that we should all pay attention to if there's documents or advertising or documents that may be considered either advertising and labeling, whether FTC should also be on the radar screen for our industry. This slide talks about how we've seen some warning letters that are focused on cosmetic surgical centers, not just the manufacturers of products. That's an interesting development, and certainly FDA has authority to regulate them too if they're looking at the products themselves as being misbranded or adulterated. In the wake of the New England compounding centers, compounding problems up in New England, I guess I should say, the agency has begun to focus on pharmacy compounding as an enforcement priority. And in April of last year, they stated that they were going to make 29 pharmacies priority inspections, and they issued 43 to all of those pharmacies except one, finding problems with respect to their manufacturing. The Compounding Quality Act, which was issued as part of the Drug Quality and Security Act at the end of last year, clarified FDA's authority to regulate compounding pharmacies, and they've started to act based on this new authority by issuing warning letters in January 2014. Peter also mentioned the manufacturing practices are a big focus, or maybe the next big focus for DOJ. Certainly within FDA, they've always been a very large focus, and what we're seeing is that FDA is always citing, or very frequently citing, inadequacies in the procedures themselves, not necessarily even in the actual production and manufacturing process. So the key to take away from that is that it's important to have procedures, it's important that you certainly follow the procedures, but that the violation in and of itself is not having the procedures or adequate procedures. So that's something that you can preemptively do, that you can review your procedures and make sure that they don't violate CGMP. Just quickly, the user fees, there was a warning letter that was issued last year that was an interesting one because it related to the failure to self-identify the need that you were subject to user fees. And FDA, given its tight resources, may be focusing on those types of violations as well. And there's lots of penalties that are associated with the failure to have user fees. Briefly, I'm going to turn this over to my colleague Jessica Ritzik, who's been following track and trace legislation since its inception, and she's going to talk briefly about the issues related to that.
So the Drug Supply Chain Security Act is part of the Drug Quality and Security Act, which also encompassed the compounding bill, which Annie talked about a few minutes ago. In comparison to the compounding bill, the supply chain section was about 100 pages long. The compounding section was about 30 pages long. The compounding section, FDA has issued a bunch of guidances, et cetera, already. The drug supply chain section requires a lot of different milestone actions on FDA's behalf, which you can see some of them are up on the screen. But the big goal of this is for an interoperable electronic pedigree system to be in place in 10 years. So throughout that 10 years, there are a bunch of different things FDA needs to do. The first big milestone was recently in January 2014, the state pedigree preemption provisions kicked in, but what's interesting about that is now state pedigree rules and laws are preempted, but FDA has nothing in place to kind of take over. They haven't issued any guidances. Their regulations haven't come out. They're not even in draft form or anything like that. So there's some question about what really applies right now. Is it the Prescription Drug Marketing Act, et cetera? FDA has said that it's working on it and they plan to get things moving, but so far it's kind of in a weird sort of purgatory state. But that's something that, especially over the next 10 years, looks like it's going to be a big deal.
Thank you, Jess. So that's all I have. I was going to turn it over to Peter, but I think we'll turn it over for questions if we have any time.
Annie and Peter, thank you so much for the presentation. It was very, very good. Thank you. We actually did have a few questions that came in from the audience that I would like to pose to you if you have some time to answer a few questions. One of the questions that came in was as follows, and Peter, I think this might be directed towards you. What do the new J&J compliance programs look like? Are there any key provisions or components they need to implement?
Good question. I mean, the corporate integrity agreements really are an evolution, and so you see, you know, the typical training, certifications, audits and reviews, reports of reportable events, corrective action requirements, all of which really are designed to try to take the company forward. But I think that what's new about it is the emphasis on proactivity as opposed to reactivity. And the proactivity really stems from the risk assessments that I talked about. You know, you need to do an enterprise risk assessment. Look at the entity, identify potential areas of problematic behavior or issues, and then do analyses and take steps to close the gaps that are identified. So it's that proactive approach as opposed to the reactive approach that I think is one of the new features and new approaches that the J&J Corporate Integrity Agreement exemplifies, and that you will see being an expectation in compliance programs throughout the pharma industry, the device industry, and the food industry, as well as other related industries.
Thank you, Peter. Annie, a question for you. Will the plan to specialize FDA's workforce include the criminal agents in OCI?
You know, FDA has not specified whether or not the agents within the law enforcement agents in OCI will be subject to this reorg and specialization. I think that they should, if somebody were asking my opinion. I think it makes sense to have the criminal agents just as specialized. And certainly in training that does occur, I mean in practice that does occur, that cases get assigned to those who have previously worked a device case or a drug marketing case. But FDA has not stated to that level of specificity that it would impact the law enforcement agents.
And Annie, another question for you. What about the issue of individual liability? Do you think the government will be focused on holding more individuals responsible for the company's conduct?
This has been a trend that has been stated to be a trend for the last 20 years. So I'm not sure if it's any more of a trend, but FDA has repeatedly stated that it intends to hold individuals liable, both for actual direct conduct as well as under the Park Doctrine, which holds an individual responsible simply because of their authority over conduct within the company. So I do see that individuals are being held responsible in the civil arena. They're always being named to consent decrees and civil injunctions. In the criminal arena, I think it's harder, but I see FDA doing that more. The most recent prosecution or affirmation of a conviction in the 10th Circuit under Schulte also held the CEO responsible for the company's conduct there. That related to false statements that he made during an inspection, but still you could see that the government was really focused on holding an individual responsible.
Thank you, Annie. And one more question for you, Peter. Could you please repeat the explanation for the ruling in the first sales rep case, Carolinas?
So it's Coronia. And the explanation I would give, I guess, is that what the Second Circuit held is that truthful, non-misleading speech about off-label uses can't be prosecuted as a crime. It's essentially, it is protected by the First Amendment. But what we always hear the government say in these cases is, that's all well and good. What we're talking about is speech that is not truthful or that is misleading. And the misleading prong, potentially could be the juxtaposition of facts that are true but in a misleading way, or the omission of information that's necessary to make a statement complete, to give a complete understanding. So think about it as, Coronia being a very, very narrow exception that you don't want to rely on.
Thank you so much, Peter, and thank you again, Annie, for a wonderful session, very informative, and thank you everyone for attending today's session. As my colleague Matt mentioned at the start of the webinar, the slides will be made available to anyone who requests them. You could please send that email to matt@momentumevents.com. We have also recorded this session, the slides as well as the audio, and all of the participants in today's session will receive a link with more details and information on how to access the materials immediately following. Thank you again, Annie and Peter, and we'll look forward to seeing you all at the next Momentum event. Thank you. This now concludes our webinar.